instructions. And instructions have to be specific on what to deal with. And when you receive instructions, you've got to first of all have a discussion with your client and agree on what you are going to handle before court. Yesterday, we received a production warrant inviting us here, and we were never given the reason why this session had been organized by court. It's on record on Wednesday when we last appeared. Court adjourned the matter to 29th next week. Against our honest and humble plea that please, let's have a very short adjournment because there were pertinent issues concerning the liberty of our clients who wanted to raise. Those are issues which are canvassed under the Constitution. The issue of mandatory bail. And these are matters of law. We brought to the attention of court this fact that our clients had spent more than 180 days on remand. And the Constitution commands that once that happens, court has no choice but to release their chosen persons. And Section 76 of the Magistrates Courts Act, which reinforces the letter and the spirit of Article 23, is very, very categorical. It's clear that once the accused persons have spent 180 days on remand in matters which are exclusively triable by the High Court, no any other business should be handled by that court except entertaining the application for mandatory bail. And that is the matter we wanted to be addressed on Wednesday this week. Unfortunately, the substantive magistrate who is charged with the handling of this matter was not available. And then there was a stand-in magistrate. We requested him that please accommodate us this week so that we can make that application. First of all, he asked for Thursday. He refused. We pleaded and said probably Friday. He said please, the trial magistrate or the magistrate in conduct of this matter had given him strict instructions to adjourn it to early June, no any other date. It was by compromise that we agreed on 29th of this month. And they indicated that this week there is no date. Or rather, there is no space. They indicated there was no space to accommodate us this week. That was the position of court. So in a surprising twist of events, last night, they issued the criminal summons or production warrant rather. They issued production warrant, and shockingly, the state that moved the court to issue production warrant raised the communication which they never shared with us. That is weird. That is irregular. Because as a matter of law, they ought to have served us with a copy of the letter that moved the court to issue the production warrant for today. Even up to this particular moment we are speaking right now, we have not seen the contents of that letter. The state is holding it as if it's classified information. So when we raised these issues before the magistrate, we thought they would be serious, rather they would be accorded the seriousness they deserve. We thought the magistrate would grant us that opportunity. First of all, to make the application for mandatory bail. Then surprisingly, no, actually it's not an opportunity. Let me repeat this. We expected the magistrate to comply with the dictates of the law. That before you proceed with any other matter, first consider the application for mandatory bail. That is the law. It came as a shocker to us when the magistrate said, let the state first tell us why we are here. Meaning, even court, which issued the production warrant, wasn't aware why we are here. For us, we could not get to understand the reason why we are here from the state. It is court to tell us. It is court that issued the production warrant. So, we felt we were insulted. With all due respect to the chief magistrate. You cannot tell the opposite counsel to tell us the reason why we are here when actually it is court that summoned us. It's court that issued the production warrant. So even the magistrate was oblivious of the reason as to why we are here. And on that ground, coupled with the fact that our senior colleague was not here, because Martha Karua is the lead counsel. And there is a reason why the chosen person took that decision to have Martha Karua as our lead counsel. And we wanted to work out a proper schedule. Because she jetted in on, early this week, and the whole of this week had been reserved for this case. And it's the reason we asked the court, we asked the court, please, can you fix this matter either Thursday or Friday? Can you accommodate us this week? For convenience purposes. But the court insisted that it should be next week. So she had to go back to Nairobi. Now, immediately after she has returned to Nairobi, you issue production warrant. Are you being fair? Are you being just? So this is the, rather, are you being fair or reasonable? So it's the reason we had to withdraw from the bar. And obviously you had the statement from our client. We have not had any opportunity to discuss these matters with them. And it would be very, very unprofessional on our part to proceed under those circumstances. One, where you have no instructions, you have not discussed the matter with the client. Two, you have no idea as to which matter is going to be handled before court, and therefore you are not prepared. Let me tell you, the worst thing a lawyer can do to yourself and your client is to appear before court when you are ill-prepared. So we came here prepared to handle the mandatory bail application, not anything else, because that's the command of the law. Now the magistrate was telling us to go into something else, which was not known to us. So we had to withdraw and wait for the date that was fixed for the mention of this matter. That is 29th of this month. That's the next week. So that's when we shall be back here.
What is your take on the issue of the prosecution saying that the accused appeared before this court on 21st February? For you were saying that they have spent 180 days on remand. What is your take on that? According to counsel Joseph Chomuhendo, who said so that they were charged in this court on 21st February. So the 6 months we are talking about, they are not yet. What is your take on that?
It also explains the reason why we had to walk out, because he also appeared to be ill-prepared. He was not seized with the facts. I'm sure when we come back on the Thursday to raise that application, he will not raise that vexatious argument. I don't think he was very serious about it. It would appear he is not in any way informed that actually these people have been on remand since November last year. It would also appear that actually he has not taken time to educate himself about all the matters concerning this case, that it has got a long history from the General Court Martial, which also issued the remand warrants, up to the time when the Supreme Court quashed the proceedings. That is the 31st January. I'm sure he hadn't updated himself about those developments.
Maybe lastly from me, how is it important for a lawyer to represent a client in court without instructions? Because that is the ground, that the reason why you had to move out of the court, one of it. How important is it in the law?
It's criminal conduct. If you attempted to proceed without instructions, it's not only a professional misconduct, but it is a matter that invites criminal sanctions against you. It's criminal. Do you know the gravity of this matter? The sentence is death. You purport to represent somebody without instructions, or when you are not at all prepared, and inadvertently cause a miscarriage of justice, that can lead to execution of somebody, taking away somebody's life, and you take that matter lightly. Not any of us here. For us, we know the implications of the decisions being made here. We know why the state is making all these machinations and maneuvers. We know what they are up to. They want to execute Dr. Besigye. They want to kill him. They have said so. This is a perfunctory process. They are just taking him through a process leading to the gallows. We cannot, we would be the last people to escort Dr. Besigye and Obedi Lutale to the gallows. Twazze wano nga tetumanyi ensonga etuleese. Naye tuteeka ekitiibwa mu kiragiro kya kooti kye bayita production warrant ekigamba nti Dr. Besigye n'Obedi Lutale babakomyewo olwaleero. Twakoma okujja wano ku Wednesday, omusango ne gwongerebwayo ku Thursday 29th. Baatugamba nti omulamuzi agubeeramu teyaliiwo, nti yali mu meeting. Ekyatuyisa obubi. Era omulamuzi eyaliwo, mujjukira bulungi abaali wano, yagamba nti mukama we eyamugambye amutulire musango ogwo yamuwadde June either nga 2 oba nga 5, talina kirala kyonna. Ne twegayirira ne tumugamba nnyabo sebo senior counsel Martha Karua ali wano wiiki eno, twagala kuorganizinga bulungi. Ekyokubiri, bakiransi baffe bawezezze ennaku 18 ku rimandi. Ate ssemateeka mu nnyingo ya 23 ng'ogisomedde wamu n'akawaayiro namba 76 aka Magistrate Courts Act. Birambika bulungi ki ekiteekeddwa okukolebwa singa omuntu amala ennaku 18 ng'ali ku rimandi, nti olina okumuwa gye bayita mandatory bail. Omulamuzi yakomba kwerima n'agamba tasobola kutuwa lunaku wiiki eno, kooti teriiwo. Yagamba abalamuzi tebaliiwo, bali bize wiiki eno, bali bize tebaliiwo. Naga kale munaakoma wano nga 29. Ne tukkiriza wakati mu kunyigirizibwa. Martha Karua n'addayo e Nairobi. Ennyonyi yadde yakalandinga e Nairobi, ate ne batuwa summons oba production warrant nti amujje kati tugenda kuwulira olwaleero. Kati wali nsonga. Ne tugamba okay fine. Bwe baba bazze kuwulira mandatory bail, application yaffe ya mandatory bail, tuli betefutefu. Era ffe twazze tuli betefutefu okupresenting application yaffe ku mandatory bail. Ate tutuuka wano nga batugamba nti state yerina ensonga lwaki tuli wano. Twewuunyeza nnyo omulamuzi naye yennyini nga tamanyi lwaki tuli wano. N'agamba nti mukkirize state yetubuulire lwaki tuli wano. Ngate state si ye yatuyise, production warrant kooti ye yagiyisizza. Ekyokubiri, state n'ebanga yeesaba eteekawo ensonga ez'essimba mu buwandiike n'eziteeka mu kooti, naffe netuwa kopi nga tetunnajja wano ne tusobola okupreparinga. Kakati ebbaluwa eyo eya state oba eya gavumenti tetugirabangako, n'okutuusa olwaliro tetunnagirabako, n'ensonga ezirimu tetunnazirabako. Eyo gye bayita trial by ambush. Lawyer yenna olina okujja mu kooti bw'obeera nga oli worth your salt, bw'obeera nga oli lawyer alimu akaniguusa, oteekeddwa okujja nga weeteeseteese. Mu butuufu twazze wano nga tetweteeseteese ku nsonga za state za gavumenti zeereeta kuba tetuzimanyi. Ate mu kweteekateeka olina n'okudisikasinga ne kirayanti wo. Twabadde tulina okusooka okutuula ne Dr. Besigye ntugamba omanyi nno nti ekibagenda okusaba kyeki kino ne kino ne kino, tukikutte tutya? Ebyo byonna tebyabaddewo. Kakati omulamuzi tubimugambye nga ffe tuli redde ku application yaffe eya bail, naye ebiyo ebirala ebya state tetubinaako instruction, tetubimanyi. Nyina alemerako. Era awulidde Dr. Besigye n'amugamba nti bano sinnabawa instructions kugenda mu maaso na bintu ebyo. Instructions za bail application. Ekyokubiri, ne lead counsel Martha Karua yabadde wano nga alina special assignment gy'alina okukola mu kooti, yazzeeyo. Kakati ekyo kibeera si kya bwenkanya. N'olw'ensonga eyo omulamuzi ne tumugamba kijja kuba kya bulabe ffe nga balooya ogenda mu maaso nga tetulina instructions ate nga tetweteeseteese. N'olw'ensonga eyo tumugamba munnaffe ebigenda mu maaso tufulumye tugenze tukulekedde abantu bo gwe kola ky'oyagala ffe tulinze komawo wano nga 29.
Kanso yogera ki ku nsonga ya state wegamba bo emyezi 6 gye mwogerako teginnaba kuwera mbu abantu bano babaleeta mu kkooti ng'ennaku z'omwezi 20 omwezi ogwokubiri naye mmwe mugamba nti bamaze mu kkooti oba mu mabega g'enkomi emyezi.
Kyemmanyi kanso ky'omuhenda akyogedde abadde tayina facts, alabika tannamanya nti waliwo n'omusango gwa Kabaziguluka, alabika tannamanya nti bano baaliko mu General Court Martial. Manyi bw'anaddayo n'asoma ebintu ebyo n'arefreshinga memory ye n'akola buli kimu bwe tunaddira ku Lwokuna nga 29 tajja kukiddamu.
Kyabulabe ki ekiri mu nsonga y'abannamateeka okugenda mu maaso nga tebafunye buyinza okuva eri omuntu gwe bakiikirira mu mateeka kiba kikosa kityo?
Ogwo omusango tugamba mu lufuutifuuti ti gubeera criminal. Obuzizza omusango basobola n'okuteeka wali mu kaguli okubeera impositor. Era gusobola n'okusazisaamu practicing certificate yo. Law Council esobola okuwozesa ne bakusazaamu ne practicing certificate yo. Ate ku legal team eno njagala okubalaga omwami ono Abubeka Sekanjago. Ono mulabo ono ye akiikirira Uganda Law Society ku Law Council. Law Council ekulembera mukyala Irene Mulyagonja. Bano be batuulayo ne batukangavvula. Kakati ono y'omu ku bakangavvula ba looya okumenya amateeka. Kati atuule wano naye agamenye addeyo eri mu Law Council ng'ate yalina okukangavvula nedde kyalibadde kya bujjega nnyo gye tuli. Ekyo badde tetuyinza kukikola.
One, on the question of the state moving this honorable court to secure a protection warrant, that there is a letter on record. It's personal profession for one to write to court and we do not share a copy of the communication you have filed on record with the opposite side. Very unprofessional. Up to now, up to this particular moment, Your Worship, we have not been given, we have not been favored with a copy of that letter. That shouldn't be taken lightly. And it's not a favor. It's a right that whatever even you put on record, serve the copy of the opposite. That's a command of the So we are really taken aback by that submission. It shouldn't have come from a chief state attorney that they've moved the court and they never sacked us. Your Worship. Secondly, Your Worship, they insinuated that indeed actually they had no objection to the adjournment of this matter this week. Actually, that they were in agreement with our prayer that this matter be fixed either yesterday or today. I hope he is also in agreement with the reason why we moved the court to have it heard today. Because the reason we wanted this matter to be entertained yesterday or today is on record, well captured on record. To give effect to the letter and spirit of Article 23, which dictates that once an accused person has been on remand for a period of 180 days, the next course of action will be mandatory pay. So if that is the reason we are here and is in agreement with that, then we have no problem. If we are here for a different reason, and that he moved to court to make other prayers, we have issues with that. If the court was, this session is about that application, and the accused person is being released because they have spent more than 6 months on remand, and the command of Article 23 is very clear, read together with Section 76 of the MCA. Your Worship, if I may, for the record purposes, read this section 76. Resolution on period of pre-trial remand. If an accused person has been remanded in custody before his or her trial commences.
But Your Worship, before my senior colleague, without due respect, she's raising new issues. There's nothing like that came up. We never talked about that application is talking about. Neither did he even bring it up when he was actually making his first submissions in chief. So I think it is my submission that that is irregular. Let him stick to my response.
Your Worship, this is not an LC court.
No, but
There are procedures, there are rules. If I may be permitted to make my submission, and if you so wish to respond, you will know what to do. You can apply for leave.
but you cannot raise new issues when I'm seeing.
It's fine, let him submit, then we
Your Worship, I was reading that particular provision. If an accused person has been remanded in custody of the field before his or her trial commences, A, in respect of any offense punishable by death, for a continuous period exceeding 180 days, or B, in respect of any other offense, for a continuous period exceeding 60 days. The magistrate before whom the accused person first appears after the expiration of the relevant period shall release him or her on bail on his or her own recognizance, notwithstanding that he or she is accused of an offense referred to in section 75, and so on and so forth. It continues. Unless, maybe let me complete it. Unless A, he or she has prior to the expiration of that period been committed to the High Court for trial, or the magistrate is satisfied that it's expedience for the protection of public that he or she should be released from, and so on and so forth, Your Worship. So, the reason we have requested for this day, Your Worship, that's what I will testify, is to respect, give protection, and to enforce this particular provision. Section 76, read together with Article 23 of the Constitution, because they had spent more than 60 days, more than 180 days on remand. That is 6 months. And the command of this particular provision that once that period has elapsed, the magistrate, before whom they first appear, before any other action is taken, it's the issue of the release which has to be considered. Once the period of 6 months has elapsed, the first appearance before magistrate is about this. So we cannot do any other business today. And that is the reason we have asked court to accommodate that this week. I am glad he said he was in agreement with that. So if that's what brings us here, we are ready to proceed and make our case. That's the argument I was making in response to the issues he had raised, that he was in agreement with us for a fixture of today. Then about senior counsel Martha Kauma not being part of the legal team today, it's very absurd to hear the state attorney make such outlandish statements. And we take exception. That her presence here is of no relevance is inconsequential. Your Worship, the command of the Constitution again. Look at the provisions of Article 23 and Article 28. The liberties of an person to choose their way is well guaranteed under the Constitution. It's not about the competence or incompetence of those who are here. No. The court wouldn't delve into that. To say, are those who are here are competent enough? No. It's about the right of an accused person under the Constitution to choose their lawyers. It's about giving respect back to you, enforcing it. For heaven's sake, the accused persons are not about to disclose the reasons why they chose senior counsel Makatawa to lead the team. And the state is not allocate themselves that duty of making a choice for them. To suggest that Martha Karua should stay here permanently is equal outrageous. It's on record she was given the license to handle only one case, this one. It's a matter of logic. I don't even need to cite any law. It's a matter of logic. But a person who is outside the jurisdiction of this court cannot stay here to handle a case which is not being had on a daily basis. And the reason we had asked court to adjourn to either yesterday or today is a question of convenience. And we thought this is just a simple matter, it's basic, one would appreciate it. That one will not stay here and wait until 29 when you are a resident of Nairobi. That is outrageous, without due respect. Then, finally, on the question of saying, I don't know how it is future is here. Your Worship, before court commences, this is a court hearing. Court means the setting we are having right now. No one, nobody in the gallery has attempted to sing in the court or before court. Here come, they are attentive, they are listening to the proceedings. I know of no law that prohibits anyone from expressing themselves before an empty podium. I am talking about a podium. A matter which is political in nature. Definitely you would expect it. There's no way you're going to divorce politics from a matter which is politically motivated. That they have sung about him, about 7 horse. No one can sing about it. I mean, as long as it doesn't offend the law. So your worship to be on record. If one say, "Lukwago, you will die," that's a given. That's a given. It's divine ordained that one of us shall die. But if it offends the law, then there are procedures you have to follow. under the law. You don't simply use goons, hoodlums, to kidnap members of the public. No one has been charged with any offense. No one has been in any way presented before court, here or anywhere, in relation to what you are talking about. So you just pick people, brutalize them, and cheat and dump them the way you deem fit. Your worship, court should have tolerated that. So, in a nutshell, your worship, we reiterate our prayer that you be pleased to grant the relics we sought, but also to permit us to proceed, your worship, to make our prayer for the liberties of the accused persons under the provisions of Article 26, 23, and Section 76 of the LC. Article 23 of the Constitution and Section 76 of the LC. And the state shouldn't be allowed to proceed with any other matter apart from this issue. That is our prayer, your worship.